Chair calls Ware Wendell. You know the drill, my friend.
Thank you, Mr. Chairman. Ware Wendell, representing Texas Watch, in strong support of House Bill 2374. First, thank you, Representative Johnson, for bringing this bill. It would solve a big problem out there for many policyholders, many motorists on our Texas roads. There's a King's X period here that's being exploited, and the King's X period is very important. We support everything out there that cuts down on barratry, solicitation, all of that. The penal code criminalizes lawyers who chase after people, and we support that. Our disciplinary rules as lawyers have very strict rules in place. We have to get letters approved. If you're going to contact someone after 30 days, they have to be clearly marked. All of that is very, very important. We support all of it. The government code, Chapter 82, voids contracts that are entered into with lawyers that are in contravention of those laws.
Let me just say something.
Yes,
I will take a little exception to our barratry laws. I think with rare exception, they're not really enforced. We have case runners in South Texas who make the practice of law, make people question the integrity of the practice of law. We need to do, you're just touching on a personal issue that I've dealt with the last 12 years. You know, I've had cases stolen from right under me because they're giving them money up front and making them promises that I would refuse to make. In criminal practice of law, you have bail bondsmen getting a cut of the legal fees. So to say we have barratry, laws in place, I think we need to take that with some exception or a grain of salt.
I'm amening you, Mr. Chairman. I support you 100%, and I agree, and those laws should be strongly and strictly enforced.
Appreciate it.
And they aren't always.
Yeah.
So I agree with you, and we need to make sure that folks are protected right after the wreck. But the problem here is that the insurance companies are swooping in. Some are. And I'll be happy to provide the case to you. It's Gilbert v. Fitz out of the Dallas Court of Appeals that authorizes these oral releases over the phone when you're hurt, when you really don't know what your treatment is. And merely saying yes on the phone call is enough to extinguish your legal rights. You have a letter signed by nearly 500 Texans asking you to please take action on this. And so the bill prevents any double dipping. If there has been a release,
saw that. Yeah.
You're not going to get paid again. All right, that's credited back. And Dr. Oliverson, I'd like to emphasize that really the only open period here that matters is that 45-day period. There is certainty, there is finality on the 46th day, in essence, under the bill. It doesn't extend out to the year because if you enter into the release on the 46th day, then you don't have that year period to void the release. So it's just the 45-day period that we're looking at. If you're unrepresented, you don't know your rights. And these are folks who maybe they've been treated in the ER, but they haven't yet gone to the specialist that they're going to need to see. And we want to make sure that those doctors are getting paid as well.
I want to clarify what you just said. You're saying if a settlement is entered in on the 46th day, then that year period to reopen the claim would not apply.
Correct.
Okay. So then, in essence, it's creating the 45-day cooling period?
Correct.
Okay.
Yes.
Vice Chair Oliverson?
I think my question, since you called me out,
just trying to be responsive.
My concern is not with the 46th day and what happens after that. My concern is, as was mentioned by several committee members, I don't think this addresses the underlying problem. I think this just creates more uncertainty, which is completely unnecessary. If the concern is what happens in day 0 to day 45, then address that specifically. But we don't add on to existing law this, the rest of the year you're kind of up in the air. You don't know whether you're going to be sued or not. I mean, I'm also seeing the notices playing on the TV and stuff like that. It seems to me if what we're really concerned about here, per your organization, is justice for an injured party and predatory practices, then deal with that. deal with that 45-day period, do away, as Chairman and Chairwoman Davis suggested, do away with the telephone release, put a mandatory cooling off period that they can't approach somebody for the first 15, 20 days after. That would solve the problem. This creates a secondary predatory practice, in my opinion.
And I hear you, and I support that as well. And I'm happy to talk with you and your staff. I do think that the bill as written creates that 45-day cooling off period so that treatment can be sought, so that people do understand the full extent of their injuries under B1 in the bill. I'm going from memory here. But I hear your concerns, and that is solely our concern here, that people have time to understand the full extent of their damages, because if they're not fully compensated, as Milton Friedman said, there's no such thing as a free lunch. That cost has been borne. It's now borne by the person wrongfully. It's borne by their medical providers who aren't going to get paid. And that's not what we're trying to do under our laws here.
Chairwoman Davis.
I think that the concern is, and correct me if I'm wrong or if I'm misstating anything, in Texas there's a 2-year statute of limitations for personal injury claims. So the uncertainty, I think, is that you could have a claimant enter into an agreement over the phone on the 45th day. The insured then thinks that the claim is settled, but because there's a 2-year statute of limitations, there's actually 2 years in which that person could at some point contact a lawyer and say, hey, I signed an agreement, on the 43rd day after my claim, and I don't think that was enough money, so now I want to file a lawsuit. And they could make that claim 2 years to the day of the accident, even though they had already entered into a settlement agreement on the 42nd day after the accident. So the insured thinks this claim is resolved, but in fact it's not, and there's an almost 2-year period in which they can be sued. Is that?
Yeah.
There is that outlined 2-year statute of limitations, but that's where you put the 1-year void language in the bill. So there is a cap in there. Again, if you're within that 45-day period and you are not represented, so you don't fully understand your rights.
Okay, so then it's still a 1 year then,
Correct.
Right? You enter into a settlement on the 44th day after the accident, but the insured really doesn't know what's going to happen for a full year.
So day 0, day of the event, to day 45, no lawyer. You enter into a release, an oral release. You would have the right to void up to a year, and you're credited back. The insurance company is credited back whatever money they have paid already. So yes, there's a 0 to 45-day period, and it goes out to a year potentially. But on that 46th day, whether you're represented or not represented, you don't have the uncertainty of the year here if they get you to sign the release.
But there's still, I think the concern is there's still at least that full year if you have an insured that's entered, or if you have a claimant that enters into a settlement within the first 45 days.
And this is a balancing act. This is the public policy that you have to set here as to making sure that people are fully compensated, their providers are fully compensated, and that these things don't drag on forever either. And I hear those concerns.
Chairman Turner.
Thank you, Mr. Chairman. So I understand. And so if under the bill, if it were to become law, if an insurance company settled with the injured party on the 46th day or later, then there is no ability for, whether with or without legal representation, there is no ability then for the injured party to come back later and sue.
That's exactly right, Representative Turner, because they've signed the release, they've given up, they've extinguished their legal rights. There's no statute of limitations. There's no case. It's done.
So the insurance company wanted to, ensure that have that certainty that they wouldn't be sued. Then any sort of settlement day 46 forward would provide that assurance.
That's right.
If it's within the first 45 days and the injured party is represented by an attorney, they also have that assurance.
That's right. And I want to be very clear. We value the prompt resolution of claims. You've heard me say that many, many times. And I believe that this bill would facilitate that. The question is day 4 or day 46. That's still very prompt, but we want to make sure that people understand the extent of their injuries, and they've been able to seek treatment so that they know exactly how broken their body is.
Well, for whatever it's worth, the 45 days is more days than we have left in this legislative session. So it's not a very long period of time.
Each day is feeling very long these days, though, I will say that.
45 days for my wife and kids at home is a long time. Vice Chair Alverson.
Just one more thing. Again,
Yes, sir.
I think you're creating a second group of victims with this bill. And that is that you're creating a group of victims you have policyholders who believe if this bill passes that their claim has been settled, and then they find out, much to their surprise later on, that in fact it has not. And that's what I don't like about the way you're trying to solve this problem. I think it would be much more forthright to go through the front door and just say, look, we think it's unreasonable to settle a claim that quickly, particularly over the telephone, and we want to see that practice go away.
I hear your concerns. We certainly don't want to create a second class of victims, and I'm more than happy to talk about them offline.
Members, any other questions? Thanks for hanging in there, bud.
Thank you, Chairman.
Appreciate it.